everyone. Welcome to LexTalk World Talk Show presented by ClickAway Creators. Today we have Vaneesha Jain with us. Vaneesha is an associate partner with Saikrishna and Associates. She works on policy matters with a specialization in technology, copyright, and data protection. As one of the leading practitioners in the privacy law within the firm, Vaneesha has advised some of the world's largest technology companies during the various stages of consultation in the formulation of the Indian data protection law, including with the filing submission to the Ministry of Electronics and Information Technology. She has also assisted the petitioners in the landmark Aadhaar case, which led to the historic 9-judge bench decision that now forms the bedrock of the privacy law in India. That is quite a journey, and I've not even started yet. When it comes to Vaneesha, as much as I have had a conversation with her, I know a lot about her. I have read about her. She has told me a lot of things, but let me just not take all the screen time and let me introduce you to Vaneesha herself. Hello, Vaneesha. How are you?
Hi, Bharti. Good to be here. Thank you for having me here.
Thank you for being here. It's a pleasure having you here, and we're actually very excited to know about your journey as a legal professional so far.
Well, I got my first law degree from the West Bengal National University of Juridical Sciences in 2011. And I went on to get my master's from the New York University in 2015. Ever since I've been back in India, I've been working with Saikrishna and Associates. And currently I'm an associate partner there. I primarily these days work on policy issues in the space of copyright law, as well as do a lot of work in the data privacy and technology law sphere.
Thank you so much for throwing light on your journey so far, Vaneesha. Now, coming back to my favorite question, like this is my all-time favorite question. So it used to be a memorable case, but now I would really like to know about the complex legal issue that you've worked on. And if you're comfortable with that, you can describe the complexity of the matter and how did you approach it?
Well, I think one of the things that I worked on that really stands out to me, and I feel like I learned a lot in the process of working on this, was, when I was working on copyright policy, when you speak about copyright policy, I think one of the landmark events that has happened is the amendments that happened in 2012. Those amendments were very impactful for a variety of different reasons. Not the least of which is, honing the regulations around copyright societies and the rights that accrue to authors and composers. But I also got a chance to work on them from the perspective of how these amendments were made in order to align and bring the Copyright Act up to speed with the nature of the internet. So the original act was actually first drafted way back, and the Indian it comes from the Statute of Anne, but it's dated 1957. So shooting ahead to 2012, the drafters recognized the need to bring a lot of the provisions up to speed with the digital era. And to that effect, they said, there are these WIPO, that is the World Intellectual Property Organization, has come up with these treaties for the digital era, which are popularly called the Internet Treaties, which are two. One is called the WCT, which is the WIPO Copyright Treaty, and the other is the WPPT, which is the WIPO Performances and Phonograms Treaty. So one of the objects that the legislators had in mind when they were coming up with the 2012 amendments was to actually update the copyright law, which so far had dealt with things like, record players and, very manual things, photocopying of books and things, and update that and apply the same rights to the extent possible in the digital era and update it where required. So I had a chance, I would say, to literally do a clause-by-clause analysis of these international treaties and analyze to what extent the Indian law is actually compliant with it and how far we actually exceed the protections that are given in some ways. So I worked with the department, the DPIIT, which was then called the DIPP under the Ministry of Commerce. And I think it was really great for me personally because it goes beyond as a lawyer, just applying the law as it is, but to actually engage with what the law should be, and especially in the context of where your country is situated, in relation to the international, what's going on in the international domain. So we actually prepared an advisory for the government as to, the pros and cons and the impact of acceding to these internet treaties. And India actually did accede to the treaties in 2018. So that I would say is one of the experiences of working at the firm in the area of copyright policy that I cherish.
Thank you so much, Vaneesha. This was actually quite interesting and different from what people have discussed on this platform. So Vaneesha, the pandemic saw courts moving towards remote proceedings. So is this sustainable, and what's your take? Like, is this a possible way to increase access to justice? We would really love to know about your opinion on this.
Well, I think that's a very interesting question. And I think the answer is almost apparent, given that based on the behavior or the trends that we see happening already, which is that courts have begun to function in a hybrid model of sorts, where the online proceedings continue to happen along and side by side with physical hearings as well. I do think there are a lot of advantages that we've seen with things going online. Of course, the courts were already moving, to adapt to the digital era that we find ourselves in, with the kinds of legal technologies that are now available, with things like digitization of records and use of legal tools and software, even for lawyers. So, for example, my generation grew up on Manupatra as a legal research tool, whereas previous generations had to read reports, legal reports, and make notes by hand. But I think the push that the pandemic has given towards things like online hearings has had advantages, primarily in terms of saving time and costs for travel, for client meetings, for briefings, in addition to hearings. In terms of access to justice, though, I feel there are also cons, in that I feel many stakeholders may not actually have access due to deficiencies in infrastructure that we have, a lack in technological comfort and literacy for all stakeholders. I mean, it's across the board. So I think it will take some time for all the stakeholders to catch up, and for the infrastructure to be made such that there are no lags, and technology used for online hearings also to be made to be brought up to speed to actually enable justice and access in all its forms. But in the meanwhile, I see a hybrid model continuing where, hopefully we take benefit of the advantages that we have to the extent comfortable for all the parties involved in any hearing. And maybe some of the allied meetings and briefings can continue to happen online, along with physical hearings in addition to online hearings. But of course, how we go really depends on the course that the pandemic takes in future as well. And while we hope for the best, we have to be prepared for all eventualities.
Absolutely. Beautifully put. Thank you. Thank you, Vaneesha. Now, let's talk about your expertise. Now, you work in the area of data protection and privacy law. How did you get into this area? Can you please throw some light on that?
Well, my interest in privacy law actually started from a constitutional and civil liberties perspective. So I took a keen interest in the Aadhaar litigation that was going on in the Supreme Court. I was reading a lot about the Aadhaar project, what was the narrative around it, and what were the critiques of it. And then, since my firm was actually assisting one of the petitioners in the litigation, I kind of jumped on board. And again, that was another sort of matter that's very close to my heart, because I feel like I worked on it with a fair amount of passion and learned a lot during the process. So while I was working on that matter and we were framing arguments that showcased the dangers and problems with making Aadhaar mandatory, in order to access services that were earlier available without the need for Aadhaar. Is when these issues of the right to privacy actually were brought up in court, and then one had to argue constitutionally that the Indian Constitution actually does guarantee the fundamental right of privacy, which was upheld and acknowledged by a historic 9-judge bench. And I think all lawyers are now aware of this very landmark decision. So coming from there, and during those proceedings, the government of India made a submission about how there was already an expert committee set up to draft a new data protection law, because informational privacy is such an important aspect of the fundamental right to privacy. And this was also iterated very strongly by the bench. So that's when the first talk of the data protection law actually was, started. And since then, it was kind of a natural progression for me to actually follow the development of this law. So right from the white paper that was presented in the draft bill in 2018, the current bill of 2019, I've had the chance to sort of study it, assist clients in making submissions regarding the development of this legislation to the mighty. And there are some very interesting questions, again, even from a global comparison perspective, with the European GDPR as well as other frameworks around the world, questions surrounding strengthening consent frameworks, implementing privacy by design, obligations to report breaches, ensure transparency. Data localization is another issue, which is it's a hot button issue. And also, so it's very interesting because it's one of those areas where I feel and I've seen that industry and civil society actually have similar interests in pushing back against certain excesses. And at the same time, this is also a policy issue in terms of determining what the contours of the rights and abilities are going to be, and sort of that pushback and that constant tension between where technology is and what it makes possible and what the law and regulation will actually allow. So there's a lot to learn, there's a lot to see, there's a lot to contribute in this area of law and technology. And in India, we expect to see a lot of changes in the coming months and years.
Thank you so much, Vaneesha, for explaining how it all works and how did the journey start for you in data protection and privacy law. So you have done your LLM in the US, right, in the States. So do you think that it impacts the work you do? We just want to know your experience, like how this has been useful in your career. I'm sure it must have made some impact. So please throw light on that for us.
Well, I did my LLM at NYU in 2014-15. I was a Vanderbilt scholar there. I think the experience I gained during my LLM impacts my work in direct and indirect ways. So just to clarify, it's not necessary to have an LLM to be a good lawyer or even to do well at all. However, I think it's the soft skills that one picks up, the exposure to an international cohort of classmates. I think it just brings a wider perspective to most issues that one deals with, especially in these areas such as the ones I work in, which is more policy, bringing a policy angle to things. I think just where you can have cross-jurisdictional comparisons, I feel it really helps to borrow from approaches followed in different countries, to suggest improvements in Indian law, to critique law at various levels from an interdisciplinary perspective, and not just to sort of keep horse blinders on to implement provisions as they are. I would say there are also certain things that I learned during my course of study at NYU during my LLM that I think would be useful no matter where they're applied, irrespective of which field one works in. Such as developing a critical analytical mind to read through any piece of legal writing. It could be an academic article or a judgment or interpretation of a statute. The other thing I think is writing, the writing style that, especially given my education was in the US, the Americans have a way of writing in a very forthright, clear manner. using simple language and not being verbose. I think we as Indians can learn a lot from that. I personally feel it has helped me in drafting submissions, in drafting advisory to clients who are often from a business background, and I think they appreciate having things put simply and clearly, and not getting overly not using legalese where it's not required, or just like getting to the crux of an issue. So I feel like those are the ways in which studying abroad has helped me bloom as a professional. Not necessarily very directly, but definitely in all of these other ways.
All right, that's amazing. And as you've already clarified to the viewers that it's not important, it's just that how it has turned out for you. It's all about that. The question was about that, and the answer to the question was the same. Coming back to the last question, sadly we have come to an end of this conversation. But before I let you go, I really want to know that how do you ensure to make the best of your time? Like as a lawyer, I'm sure you have a lot of things on your plate. So how do you manage everything?
Well, I think I try to work efficiently. I'm lucky to work with a group of people, with my colleagues, and the firm has a culture of not requiring presence at your desk from a certain time to a certain time, clocking in, clocking out in a very strict manner, and allowing that kind of flexibility and trust in all of us who work there. We place that trust in each other. So long as timelines are met on our deliverables, we don't insist on policing every hour of every day that people go through. So that's, I think, a huge benefit that we all enjoy. So there are days which are so busy that they run into other days, and we take that in our stride, because then there are other days where which are much more relaxed, and then you can take that time out to unwind, to indulge in your hobbies, to share those interests with others in the workplace as well. So I think for me, this keeps me fresh and motivated. So I use my extra time to read up on other areas that are of interest, to stay updated on what's happening around us, both legally as well as otherwise. As lawyers, I think just being updated on current events, to read on other allied areas is also very, very helpful. And also to mentor and assist others in the team to meet their targets. I think, that's super important as well. I think that's pretty much how I try to use my time.
That's amazing. I guess working efficiently obviously saves you a lot of time. Like I procrastinate a lot. Like there are days in a month, like at least 2 to 3 days where I don't even feel like working, but I just have to drag myself to the office. But again, it's like the same environment like yours. It's very chilled out. You don't want to work. You don't have to work, because we kind of now have understood the value of mental health, that obviously it should not take a toll on your mental health. Everything should be balanced. So it should be like that, and it is like that. And yeah, this is pretty much it. So thank you so much for sharing such great insights with us on everything. And I really look forward to having a chat with you again on some other trending topics in the legal industry. For our viewers, if you like this chat with Vaneesha, please like and share this video, and also do not forget to subscribe to ClickAway Creators YouTube channel to appreciate what we do, and you have more coming from industry legal leaders like her. This is Bharti for LexTalk signing off. Take care. Bye-bye.